On Tuesday, March 24th, 2026, a former Nigerian governor walked into a federal high court in Kaduna, not as a visitor, not as a witness, but as a defendant. Nasir Ahmed El-Rufai, former governor of Kaduna State, former minister of the Federal Capital Territory, one of the most intellectually formidable and politically controversial figures in Nigeria's democratic history. He had spent 33 days in ICPC custody, previously 2 nights in EFCC custody. He had been arrested, granted bail, and immediately rearrested. The Federal High Court had granted the ICPC permission to access data from electronic devices seized at his residence. March 24th, arraigned, 10 counts, 2 courts, 2 co-defendants, allegations ranging from money laundering to abuse of office to the unlawful possession of over 579 million naira in severance allowances. But here's the question this channel will spend the next 30 minutes answering, and it is not the question you think. The question is not whether El-Rufai is guilty. That is for the court to determine. The question is, why El-Rufai, why now, and who benefits most from the timing of this prosecution? Most channels will give you the headline. We give you the architecture behind it. If you have never been here before, you just found Nigeria's most analytical political channel. Subscribe, because what comes next in this video is the part they hope you never piece together. The full sequence of events. The El-Rufai prosecution began on February 16, 2026, when El-Rufai presented himself to the EFCC over alleged financial improprieties during his tenure as Kaduna governor from 2015 to 2023. He was detained for 2 nights before being granted bail on February 18th. The moment he walked out of EFCC custody, he was immediately rearrested by the ICPC. He remained in ICPC detention for 33 days. On March 5th, a magistrate court approved a 14-day remand extension. On March 18th, the ICPC filed 2 separate charges. On March 24th, he appeared before Justice Rilwan Aikawa and was formally arraigned. The charges, precisely stated. Federal Court, FHC/KD/73/2026. El-Rufai and co-defendant Joel Adoga face charges of conversion and possession of public property and money laundering. The ICPC alleges El-Rufai unlawfully took 289.8 million naira in severance allowances on 2 occasions, September 2020 and January 2023, totaling approximately 579 million naira. His legal entitlement was approximately 20 million naira. The alleged excess of over 559 million naira forms the core of the money laundering charge. Kaduna State Court, KDH/KD/ICPC/01/2026. El-Rufai and co-defendant Amadou Sule of the Kaduna State Livestock Development Agency, KADLDA, face charges of abuse of office, fraud, intent to commit fraud, and conferring undue advantage. A separate allegation involving $320,800 in foreign currency has also been reported in connection with the state court proceedings. What happened in court on March 24? El-Rufai appeared before Justice Aikawa. His counsel, Ubong Akpan, immediately raised a procedural objection, arguing the arraignment should not proceed because of a pending matter involving the presiding judge. Justice Aikawa overruled the objection and proceeded. The case was adjourned to March 31, 2026 for hearing of pending applications, including El-Rufai's bail application. His defense counsel confirmed that out of 10 counts filed, El-Rufai was joined on only 1 at the Federal High Court arraignment, describing the charges as largely relating to alleged deposits into his domiciliary account and the monetization of his earnings. This is a significant procedural detail. Historical background: the 423 billion naira indictment. In 2024, the Kaduna State House of Assembly formally indicted El-Rufai over the alleged diversion of 423 billion naira in public funds during his governorship and recommended that anti-corruption agencies investigate and prosecute. The ICPC charges are the direct institutional response to that legislative indictment. El-Rufai left the APC in 2024 and became one of the Tinubu administration's most vocal critics. We will return to the question of whether his political departure has any relationship to the timing of his prosecution. The procedural objection raised by El-Rufai's defense on March 24 concerning the presiding judge was overruled. That objection will be a central ground of any future appeal. We will return to what it means for the integrity of the trial process. 2 agencies, 2 courts, 1 defendant. 2 separate anti-corruption agencies, the EFCC and ICPC, engage with the same defendant within overlapping allegations within days of each other. 2 courts are handling related but distinct charges simultaneously. 2 co-defendants are named in separate proceedings, suggesting a layered prosecutorial strategy involving multiple officials. The coordination between 2 agencies filing charges in 2 courts is not standard procedure. It is a deliberate strategy. Whether that strategy reflects the complexity of the alleged wrongdoing or the political urgency of removing El-Rufai from the active political conversation is the central analytical question. The legal framework. The money laundering charges are filed under the Money Laundering Prevention and Prohibition Act 2022. The key allegation is that El-Rufai received severance allowances of approximately 579 million naira when his legal entitlement was approximately 20 million naira, and that he reasonably ought to have known the excess formed part of proceeds of unlawful acts. The phrase reasonably ought to have known sets a lower evidentiary bar than direct knowledge, making this charge easier to prosecute but also easier to contest. The abuse of office and fraud charges at the Kaduna State High Court are filed under the ICPC Act. The co-defendant Amadu Sule from KADLDA suggests this case involves specific contractual or financial transactions within a state agency during El-Rufai's tenure. The bail question, March 31. El-Rufai has been in custody since February 18, over 33 days before arraignment. His bail application will be heard on March 31. The terms of bail in a case of this profile will be watched as a critical indicator of judicial independence and the practical fairness of the process going forward. El-Rufai's counsel stated that out of 10 counts filed, the former governor was joined on only 1 at the Federal High Court arraignment. This is not a procedural footnote. A 10-count charge on which only 1 proceeds at arraignment is a prosecutorial weakness signal. It does not mean the case is lost, but it means the case is narrower at this stage than the charge sheet suggested. El-Rufai's legal team will build on this detail aggressively. The APC departure and its consequences. Nasir El-Rufai was one of the APC's most recognizable intellectual voices. After the 2023 election, he became increasingly vocal in his criticism of the Tinubu administration's economic policies. In 2024, he formally left the APC and joined the Social Democratic Party. He was not simply an opposition figure, he was a defector from the ruling party, which is a categorically different political threat to any incumbent administration. Who benefits from this prosecution? The Tinubu administration benefits from the neutralization of one of its most credible internal critics without having to engage his arguments on their merits. A defendant on trial cannot maintain the same public profile as a free political actor. The Kaduna State government under Governor Uba Sani benefits from federal institutional validation of its Assembly's 2024 indictment. The ICPC benefits institutionally. A high-profile prosecution demonstrates prosecutorial capacity and independence. The selective justice question. El-Rufai governed Kaduna for 8 years. The alleged 423 billion naira diversion cited by the State Assembly is orders of magnitude larger than the specific charges filed.
if the prosecution is limited to 579 million naira in severance allowances, a significant sum but a fraction of the total alleged, the question of why the prosecution begins here and not at the larger alleged figure deserves a precise answer. The Kaduna State House of Assembly's 2024 indictment of El-Rufai was conducted by a legislature operating under Governor Uba Sani, El-Rufai's successor. The ICPC charges were filed on March 18, 2026, almost 2 years after the Kaduna political landscape shifted. The charge is filed in Kaduna. The presiding judge sits in Kaduna. The co-defendants are Kaduna-based officials. The geographic concentration of this prosecution in the state El-Rufai governed under a political successor he fell out with does not establish political motivation. It establishes why political motivation must be examined seriously rather than dismissed.
Now, if what I just told you surprises you, drop a comment below. I want to know what you think before we get to the part that changes everything. The signal this prosecution sends. The prosecution of a former governor of El-Rufai's profile sends a signal that travels far beyond Kaduna. Every former governor in Nigeria is watching this case. Every political actor who has considered moving from the APC to an opposition platform is watching very carefully, because the message this prosecution carries, fairly or unfairly, is that departure from the ruling party is not a politically neutral act. Northern politics and 2027. El-Rufai is a nationally significant voice in northern Nigerian politics. His prosecution removes him from the active political conversation at precisely the moment when the North's 2027 alignment is being actively negotiated. That is not a coincidence that northern political actors will fail to notice. The institutional credibility test. The test is simple. Will the ICPC and EFCC apply the same prosecutorial intensity to sitting ministers, serving governors, and APC-aligned officials against whom comparable allegations exist? If yes, this prosecution represents institutional maturation. If no, it represents the most sophisticated use of anti-corruption machinery as political instrument that Nigeria has seen in the current era. A democracy that prosecutes its critics more vigorously than its loyalists is not a democracy. It is a managed system. International standards and Western attention. El-Rufai engaged extensively with international partners during his tenure: World Bank, USAID, UK DFID on urban renewal work, education reforms, and security programs. Prolonged pre-trial detention, procedural objections overruled at arraignment, and parallel proceedings in 2 courts simultaneously are details that international human rights monitors document and that affect Nigeria's bilateral relationships and democratic credibility internationally. The diaspora dimension. Nigerian diaspora communities are sharply divided on El-Rufai. He has admirers who credit his urban renewal work in Abuja and his education reforms in Kaduna. He has fierce critics who point to his administration's handling of farmer-herder violence and the financial allegations now before the courts. The diaspora conversation around this prosecution will shape the international narrative around Nigerian democratic health in the 2027 election cycle. The strongest case for the prosecution. Let me be clear, this channel does not take sides, it takes evidence. And the case for treating this prosecution as legitimate is substantial. 579 million naira in severance allowances when the legally entitled sum was approximately 20 million naira is not a grey area. If the ICPC's figures are accurate, El-Rufai received approximately 28 times his legal entitlement. The charge sheet is specific, the figures are stated with precision, and the co-defendant presumably facilitated the transactions from within the finance function. This is a prosecutable case on its face. Misconceptions in circulation. 1. El-Rufai was arrested without evidence. False. The ICPC filed a 10-count charge sheet with specific figures, specific dates, and named co-defendants. The Federal High Court also granted permission to access electronic devices seized from his residence, which requires a judicial determination that reasonable grounds for the search exist. 2. The charges are purely fabricated for political reasons. This cannot be verified in either direction at this stage. The charges are specific and documented. What can be said analytically is that the timing following El-Rufai's APC departure and his vocal opposition creates a reasonable basis for skepticism about motivations, without that skepticism constituting proof of fabrication. 3. El-Rufai's 33-day detention before arraignment is unconstitutional. This is legally complex. The magistrate court approved a 14-day remand extension on March 5th, which means the extended detention had judicial authorization. Whether the cumulative period meets constitutional standards under Section 35 of the 1999 Constitution is a legitimate procedural challenge El-Rufai's lawyers will press vigorously. El-Rufai has been in detention since February 18. His charge sheet was filed on March 18, 28 days into his detention. The question this timeline raises is whether 28 days of detention were necessary to complete charges for transactions documented in the Kaduna State Assembly's 2024 indictment. If the evidence was available in 2024, why did it take 28 days of detention in 2026 to produce a charge sheet? That question does not establish innocence. It establishes a legitimate procedural concern the court should take seriously. Most likely next moves. El-Rufai's legal team will press the bail application on March 31, arguing that pre-trial detention of a former governor on essentially financial charges does not meet the threshold for flight risk that would justify continued remand. Will simultaneously challenge the procedural validity of the arraignment, will begin contesting the admissibility of evidence from seized electronic devices. The ICPC will oppose bail, citing the scale of the alleged financial crime and El-Rufai's access to resources and political network as flight risk factors. Will seek to consolidate its position in both courts before El-Rufai's defense team establishes procedural footholds in either. The Tinubu administration will maintain institutional distance from the prosecution, allowing anti-corruption agencies to operate with nominal independence while the political benefits are harvested passively. Will not intervene to halt the prosecution, will not publicly endorse it. The political value of El-Rufai's legal difficulty is maximized precisely by the administration saying nothing at all. Northern political actors will watch the March 31 bail hearing as a proxy indicator of judicial independence. Reasonable bail terms signal a fair process. Punitive or denied bail intensifies the persecution narrative within Northern civil society and among El-Rufai's considerable network. Signals to watch. The outcome of the March 31 bail hearing. Whether the Kaduna State High Court arraignment date is set within weeks or delayed for months. Whether the ICPC files additional charges connecting the 579 million naira to the broader 423 billion naira figure cited by the Assembly. Whether any co-defendant enters a plea bargain, the strongest indicator of prosecutorial confidence in the evidence, and whether any other former APC governor faces comparable prosecutorial attention in the same period. El-Rufai left the APC in 2024. The charges relate to conduct between 2015 and 2023, conduct known to APC leadership while El-Rufai was still a party member. The Kaduna Assembly indictment came in 2024, after the political break. The ICPC charges came in March 2026 as the 2027 election cycle begins. The timing of initiation relative to El-Rufai's political trajectory is the most analytically significant fact in this case. It does not establish political motivation, it establishes the basis on which political motivation must be seriously examined rather than dismissed. The procedural objection raised by El-Rufai's counsel on March 24 concerning a pending matter involving Justice Aikawa was overruled and the arraignment proceeded. This objection will form the foundation of a potential appeal. In Nigerian legal practice, procedural irregularities at arraignment can be grounds for setting aside a conviction even where substantive evidence is strong. El-Rufai's legal team is building its procedural record from day one, the correct strategy for a defendant who expects the trial to be long, contested, and ultimately decided as much on process as on merit. Best case scenario. Bail is granted on March 31st on reasonable terms. The trial proceeds efficiently. The prosecution presents its evidence transparently. El-Rufai mounts a full defense. The court delivers a verdict on the merits within a defined timeframe. Whatever the outcome, conviction or acquittal, the process is accepted as legitimate by the majority of informed observers. Nigeria's anti-corruption framework gains credibility from a demonstrably fair process. Worst case scenario. Bail is denied or set at punitive levels. The trial is delayed by procedural battles across two courts. El-Rufai spends months or years in pre-trial detention without a verdict. The prosecution is perceived as political persecution. The case poisons the well of anti-corruption legitimacy, making future prosecutions of genuinely corrupt officials harder to accept as credible by a public that has drawn lessons from this one. We began with a question. Why El-Rufai? Why now? And who benefits most from the timing? The honest analytical answer is, we do not yet know with certainty. What we know is that the charges are specific and documented. What we know is that the timing follows El-Rufai's departure from the ruling party by less than 2 years. And what we know is that the alleged conduct took place during years when the same political establishment now pursuing him considered him an ally. And what we know is that the procedural conduct of this prosecution will determine whether this is remembered as justice or as its most sophisticated impersonation. Nasir El-Rufai deserves a fair trial, not because he is innocent, the court will determine that, but because Nigeria deserves a justice system that convicts the guilty and acquits the innocent through a process its citizens can trust. If this prosecution is genuine, it must be conducted with a standard of transparency that makes its outcome credible. If it is political, Nigeria will know, and that knowledge will do more damage to its democratic institutions than any single act of corruption ever could. The El-Rufai arraignment is the most politically consequential anti-corruption proceeding in Nigeria since the return of democracy. Whether it becomes a landmark for accountability or a landmark for political persecution will be determined not by the charges, but by the conduct of the process that follows. You now know something that most Nigerians watching the news tonight do not know. What you do with that is up to you. Share it, debate it, challenge it. That is how democracies survive. Afro News HQ. Nigeria deserves better analysis. See you in the next one.